Thank you. So, good evening. My name is Catherine Long, and I'm president of the Vermont Law Chapter of the Federalist Society. And we'd first like to thank you all for joining us this evening. Tonight, we welcome you to the first event of the year, and we're pleased to bring you a panel discussion on the Second Amendment. However, before we move ahead, I would first like to introduce the other executive board members of the Federalist Society. So we have Lindsay Smith over here, who is our treasurer, and Christopher Smith is our secretary, and he'll be back in a moment. There he is, Christopher. So please feel free to contact any of us with questions or interest in joining the Federalist Society. And some of you that might be newer, this is your first Federalist Society event that you're attending, might be wondering what the Federalist Society stands for. So if you'll allow me to please read the Federalist Society mission statement real quick. The Federalist Society is a nonpartisan, conservative, and libertarian organization dedicated to fostering balanced and open debate about the fundamental freedom or principles of freedom, federalism, and judicial restraint. The Federalist Society seeks to educate the legal community through its programs and publications about how limited constitutional government based on the rule of law can have a positive effect on law and public policy. Again, we welcome you to our event, and without further ado, I invite our moderator, Professor McCormick, to introduce our panelists. Thank you.
Good evening, and thank you for joining us tonight. Many thanks to the Federalist Society for always bringing different viewpoints to campus and for bringing these distinguished scholars to speak to us tonight. With that, I have the pleasure of introducing Professor Nelson Lund to you. He is a professor at George Mason School of Law, where he served as Vice Dean and as a co-editor of the Supreme Court Economic Review. Professor Lund holds a degree from St. John's College in Annapolis, Maryland, and then also a degree in philosophy from Catholic University. And he also has a degree from Harvard University and has received his law degree from University of Chicago in 1985, where he was the executive editor of the University of Chicago Law Review and chapter president of the Federalist Society for Law and Public Policy. Professor Lund has also served as a clerk for the Honorable Patrick E. Higginbotham of the United States Court of Appeals for the Fifth Circuit and for the Honorable Sandra Day O'Connor of the United States Supreme Court. He's also worked in the Department of Justice, at the Office of the Solicitor General, and the Office of Legal Counsel. He's also served in the White House as Associate Counsel to the President from 1989 to 1992. Professor Lund has written on a variety of subjects, including constitutional interpretation, federalism, separation of powers, federal election law, the Commerce Clause, the Speech, Debate, and Debate Clause, and of course the Second Amendment, which he'll speak to us about tonight. Welcome, Professor Lund. Professor Lund speaks, we'll hear from our own Professor Teachout. Professor Teachout has taught at Vermont Law School since 1975. He teaches constitutional law, international regulation of trade, legal history, jurisprudence, and argument and culture. He received his BA from Amherst College and his JD degree from the Harvard Law School, where he was a John Woodrow Simpson Fellow. After receiving his MA degree from the University of Sussex, he served in the Department of Intelligence of the U.S. Army from 1966 to 1969. He also has served as a visiting professor at the Tuck School of Business at Dartmouth College, and most recently at Boston College Law School. He has expertise that's frequently been tapped by Vermont's legislature and judiciary, and they've sought his testimony and advice on balanced budget issues, flag desecration legislation, the redrafting of the state constitution and gender-neutral language, education financing, and civil union legislation. He is the director of the VLS University of Trento and the University of Seville Study Abroad courses. Welcome, Professor Teachout. Professor Lund will first open our presentation today, and then Professor Teachout will follow him. If during the presentation you have a question, please feel free to write it down on one of the index cards provided. If your question should go to a specific panelist, please indicate so on the index card. After the presentations, a member of the Federalist Society will collect the index cards, and then we'll answer as many questions as we can. Thank you.
Thank you very much. It's an honor and a pleasure to be here, especially during such nice weather. 5 years ago, as you all know, the Supreme Court struck down Washington, D.C.'s handgun ban in the Heller decision. This was the first time in American history that the court had found any law in violation of the Second Amendment. The vote was 5-4, broken down along familiar ideological lines. Apart from its significance for the politically contentious issue of gun control, Heller was an important test case for the interpretive theory of originalism. There were virtually no relevant Supreme Court precedents, and certainly none that could be considered dispositive. Heller was also a good test case for originalism because the Second Amendment poses some genuine puzzles. Its text, for example, uniquely combines an explanatory preface and a command. It reads, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." What does the preamble's reference to the importance of a well-regulated militia have to do with the right of the people to keep and bear arms? One usually thinks of constitutional rights as obstacles to regulation, not spurs to regulation. It's not immediately evident, at least to typical 21st century readers, how this right to arms could or would contribute to the establishment or preservation of a well-regulated militia. A different kind of puzzle arises from changes in the circumstances to which the constitutional provision must be applied. American society is dramatically different from the world in which the Second Amendment was adopted. The militia organizations extolled by the founding generation have withered away, and advances in the technology of weaponry have produced arms that are far more dangerous than those available in the founding era. Is it even possible, let alone prudent, to apply the Second Amendment's command to a modern society in which it could have radically different effects than would have been expected in 1791? Heller was a good test case for yet another reason. The opinion was assigned to the court's most outspoken exponent of originalist jurisprudence, Antonin Scalia. In the opinion, Scalia made a powerful originalist case for two important propositions. First, the right to keep and bear arms is a private, individual right, not a right of the states to organize militias. Second, the purpose of the right is to enable individuals to exercise their inherent right of self-defense, including the right to defend themselves against criminal violence. But that's not enough to resolve the initial textual puzzle about the relationship between the prefatory language and the operative clause. Given that the Second Amendment protects an individual right, what in the world could that right have to do with a well-regulated militia? Scalia's effort to explain the textual reference to a well-regulated militia is incoherent and nonsensical. I won't have time to go into the details right now, but if people want to ask about it during the question period, I'll be happy to discuss that. This incoherent and nonsensical discussion of the text is the first sign that the Heller opinion, taken as a whole, is not really a serious exercise in originalism. The most difficult textual question, which Scalia never even addressed, is how codifying the right to arms could have been expected to preserve, promote, or prevent the elimination of a well-regulated militia. I believe there's a perfectly good answer to that question, but no answer of any kind will be found in Scalia's opinion. Nor does Scalia's opinion contain any evidence about the scope of the Second Amendment right to arms as it would have been understood in 1791. Now that's not very surprising. In America in 1791, the whole country was essentially like Vermont is today. There were no gun control laws. Weapons were essentially entirely unregulated, and so when they wrote the Second Amendment, nobody had any reason to ask, well, what kinds of things can you ban, what kinds of things you can't ban, who can have guns, who can't have guns. All of that was being taken care of, to the extent that it was taken care of at all, by the state governments, And because there was so little political impetus for what we call gun control laws, nobody had any occasion when the Second Amendment was being debated to ask, well, how far can the government go and regulate? Nobody wanted to regulate, and nobody asked how far the government could go in regulating. Now, Scalia's failure to identify any textual or historical evidence about the scope of the Second Amendment right had spectacular effects when he addressed the principal question at stake in the Heller case itself, namely, whether the District of Columbia's handgun ban was unconstitutional. The court concluded that it was unconstitutional, but the only reasons that Scalia offered are that handguns are popular weapons for self-defense among Americans today, and that he thinks there are good reasons why handguns are popular. Now, that is not an historical or originalist argument. If it's any kind of argument at all, it's probably a disguised and incomplete form of the quasi-legislative interest balancing approach that Scalia disdainfully dismissed elsewhere in the opinion. It's very striking that Scalia abandoned any pretense to originalism when he addressed the question actually presented in the case. What's even more striking is that he included a series of astounding and unnecessary comments endorsing various forms of gun control that were not at issue in the case. What's worse, Scalia did not provide a shred of evidence from the constitutional text or from the historical record to support his claim that these regulations are consistent with the original meaning of the Second Amendment. In a narrow sense, the Constitution was vindicated in Heller because the court reached an easily defensible originalist result. But the court's reasoning is at critical points so defective and so transparently non-originalist in some respects that Heller should be seen as an embarrassment for every justice who joined the majority opinion. Two years after Heller, the court struck down Chicago's handgun ban, holding that the 14th Amendment incorporates the right to keep and bear arms through substantive due process. Since that time, the lower courts have been faced with the unenviable task of figuring out how to apply Heller to harder cases than handgun bans. Surprisingly, perhaps, the Federal Circuit courts have largely coalesced around an analytical framework that can be roughly summarized as follows. First, some regulations, primarily those that are long-standing, are presumed not to infringe the right protected by the Second Amendment. Second, regulations that severely restrict the core right of self-defense are subject to strict scrutiny. Third, regulations that do not severely restrict the core right are subject to intermediate scrutiny. This kind of tiers of scrutiny approach is used in other areas of constitutional law, so it's not surprising that the lower courts would try to adapt it in this area, but it was conspicuously not adopted by the Supreme Court in Heller. And that problem generated an interesting debate in the D.C. Circuit, which I'll just very briefly describe. After losing the Heller case, the D.C. government wasn't willing to give up. They went back and adopted a new gun control law. And in a case called Heller 2, the named plaintiff in the earlier case, along with some other individuals, challenged several provisions of the new law, and the D.C. Circuit reviewed those challenges. I'm just going to focus on two of the provisions at issue in the case, in part because they've been in the news a lot lately. First, a prohibition on semi-automatic so-called assault rifles, and second, a ban on any magazine with a capacity of more than 10 rounds. The Heller 2 majority in the D.C. Circuit concluded that it's reasonably certain that the bans do not substantially burden the Second Amendment right. Consistent with the emerging tiers of scrutiny approach, the court then applied intermediate scrutiny, and it upheld both the so-called assault rifle ban and the 10-round magazine limit. In dissent, Judge Brett Kavanaugh argued that the majority's approach to the case was based on a complete misinterpretation of Heller. In his view, the Supreme Court has rejected the tiers of scrutiny approach. Instead, according to him, Heller teaches that courts are to assess gun regulations by looking to history and tradition, and by drawing analogies from these sources when dealing with modern weapons and new circumstances. Anything else, he maintains, involves judicial interest balancing, which Heller expressly condemned. Now, in my view, Justice Scalia's opinion in Heller is so confusing that there's no way to tell for sure which approach is the right interpretation of the case. But I think it's pretty clear that the majority's analytical approach is workable and that Judge Kavanaugh's is not. I'll just give one illustration of the problem with Kavanaugh's analysis. He argued that semi-automatic rifles are not meaningfully different from semi-automatic handguns, which Heller had already decided may not be banned. Furthermore, he said, they have not traditionally been banned and are in common use today, and so are protected. Now, this reading of Heller is technically flawed. The Supreme Court's holding involved only a particular handgun, which was a revolver, not a semi-automatic. Heller did not say, one way or the other, whether a ban on semi-automatic pistols would be unconstitutional. Judge Kavanaugh also misread Heller on the common use test. In that case, the Supreme Court concluded, and I'm going to quote this, and I apologize for the confusing language that you're about to hear, it's the Supreme Court's language. The Second Amendment does not protect those weapons not typically possessed by law-abiding citizens for lawful purposes, such as short-barreled shotguns. Now, the awkward double negative in this statement unambiguously shows that the court was careful to avoid saying that all weapons typically possessed for lawful purposes are protected. Whatever the court may decide in the future, it is not yet said that all weapons in common use for lawful purposes are ipso facto protected by the Second Amendment. But there's a deeper problem with Kavanaugh's history and tradition approach. Justice Scalia's Heller opinion itself shows that his use of history and tradition is little more than a disguised version of the kind of interest balancing that he purports to condemn. At crucial points, he simply issued ipse dixits, unsupported by any historical evidence, and at other points he actually misrepresented historical facts. Covert interest balancing, dressed up as an analysis of history and tradition, is no better than more straightforward interest balancing in the form of strict or intermediate scrutiny, and almost certainly worse. Now, that does not mean that I think Heller too was correctly decided. The challenged regulations were manifestly meant to suppress the legitimate exercise of constitutional rights, and the majority was far too deferential to the government in reviewing them. Let's start with the ban on certain semi-automatic weapons. First, the banned rifles are defined primarily in terms of cosmetic features, and they're functionally indistinguishable from other semi-automatic rifles that are not banned. The regulation is therefore arbitrary and without any real relation to public safety, and it fails the majority's own intermediate scrutiny test. Second, Heller assumed that fully automatic rifles are outside the protection of the Second Amendment. The Heller II majority analogized semi-automatic weapons to these unprotected fully automatic weapons on the ground that semi-automatics can fire almost as rapidly as those that are fully automatic. Now, that argument is fallacious. Heller treated fully automatic weapons as a special case without saying anything at all to suggest some kind of penumbral rule that protected weapons must have a significantly slower rate of fire than those that are fully automatic. What about the ban on high-capacity magazines? The majority offered two justifications. First, it said that such magazines give an advantage to what it called mass shooters. Maybe so. But how could the district's regulation possibly reduce this problem? Large capacity magazines are freely available by mail order and at stores in nearby Virginia. The court seems to be assuming that criminals bent on mass shootings will refrain from obtaining such magazines out of respect for DC's regulation. Now, rather than thoughtlessly accept this preposterous assumption, the court might well have taken judicial notice of the opposite. The majority also said that large capacity magazines can tempt legitimate self-defense shooters to fire more rounds than necessary. Once again, maybe so. But this shows at most that banning such magazines could conceivably have some good effects on some occasions. But exactly the same thing could be said of DC's original and unconstitutional ban on all handguns, which illustrates why the argument is fatally flawed. Just think about an analogous case under the First Amendment. Banning medical books containing photos of cadavers might save some children from psychological trauma. That would be a good thing too, but nobody would consider such a book ban constitutional. Assuming that intermediate scrutiny is appropriate, the government is required at a minimum to show a substantial relation between the regulation and public safety. The Heller 2 majority cited no evidence showing that the magazine ban would save any significant number of lives, or indeed any lives at all. Nor did it even consider the possibility that innocent civilians might lose their lives because they ran out of ammunition while trying to defend themselves. So to summarize, the tiers of scrutiny approach is probably the only workable analytical framework available to the courts, but it's not enough. It also has to be applied by judges who recognize the value of Second Amendment rights, or are at least unwilling to accept fallacious legal arguments as an excuse for curtailing those rights. Now, there are some judges who have been willing to take the Second Amendment seriously. In my view, the leading example is Judge Diane Sykes, who wrote the Seventh Circuit's opinion in Zell versus City of Chicago. The case involved Chicago's ban on firing ranges. This was another one that was a new law that was cooked up after the Supreme Court said you can't ban handguns. So they cooked up a new regulation with a lot of different provisions. The one that was challenged in this case was a ban on firing ranges, which happened to be in a statute that said, well, you can't have a handgun unless you practice on a firing range first. But the Seventh Circuit refused to uphold this ban on firing ranges. And Judge Sykes began by offering a more detailed and somewhat different interpretation of Heller than that of the D.C. Circuit. Briefly stated, she interpreted the Supreme Court's opinions as follows. Just as some categories of speech are unprotected by the First Amendment as a matter of history and tradition, some activities involving arms are categorically unprotected by the Constitution. To identify those categories, courts should look to the original public meaning of the right to arms. If an activity is within a protected category, courts should evaluate the regulatory means chosen by the government and the public benefits at which the regulation aims. Borrowing again from the court's First Amendment doctrine, Judge Sykes held that broadly prohibitory laws restricting the core Second Amendment right, like the one at issue in Heller, are categorically unconstitutional. All other laws must be judged by one of the standards of means-end scrutiny used in evaluating other enumerated constitutional rights, and the government always has the burden of justifying its regulations. The analytical framework adopted by Judge Sykes is broadly similar to the one adopted by the Heller 2 majority and most other circuit courts. Her approach, however, is superior in at least two important respects. First, Heller 2 adopted a view reflecting a somewhat loose consensus of other circuit courts. Judge Sykes, however, relied almost entirely on Heller and other Supreme Court decisions, and she exhibited a detailed and thoughtful familiarity with the court's opinions. It's true that Heller can be read differently, as Judge Kavanaugh showed in his dissent in Heller 2, but Judge Sykes' analysis, in my view, has better support in the text of the opinion. Inferior federal courts are required to follow the Supreme Court, but not to follow the lead of other circuits. It's therefore generally a better practice to focus on what the Supreme Court itself has said, to look, so to speak, for the court's original meaning, than to play a kind of telephone game by interpreting Supreme Court opinions on the assumption that other courts have read them correctly. Second, and of greater significance, Judge Sykes took the importance of the Second Amendment far more seriously than the Heller 2 majority did. whereas Heller too casually applied intermediate scrutiny in a way that too often accepted flimsy justifications for the regulations, Judge Seitz insisted on the kind of rigor that courts routinely demand in First Amendment cases. Unlike Heller, the Heller II majority, she gave appropriate attention to the fundamental principle expressly adopted by the Supreme Court that the Second Amendment should not be singled out for special and specially unfavorable treatment. If enough other judges will follow her lead, perhaps the Second Amendment will not return to its pre-Heller status as a kind of constitutional pariah. Thank you very much.
Professor Sand suggested that I should get a couple of Black's Law dictionaries to stand on. It's always a pleasure to hear Justice Scalia get a good intellectual drubbing, especially from my friends on the conservative side of the spectrum. So I'm going to try to do 2 or 3 things in my comments. First of all, Professor Lund started off by reading the text of the Second Amendment, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed, and posed the question, which I think he said Scalia inadequately answered, of what's the relationship between that so-called prefatory clause relating to a well-regulated militia and the operative clause, the right of the people to keep and bear arms shall not be infringed. And I think if we could, if you will, take a journey with me, if we could go back just a little bit into the history of the Second Amendment, we might be able to understand perhaps a little bit better than one can maybe from Scalia's opinion in the Heller case, what the framers had in mind in adopting the Second Amendment. And the first thing to recognize is the Second Amendment is not original. It doesn't appear out of blue sky on this continent. In fact, it had its origins in the English Bill of Rights, 1689. Those of you who are in my section of constitutional law will recognize that the English Bill of Rights was drafted after King James II fled to France because of the view that King James II, who was a good Catholic, had abused the traditional rights and liberties of Englishmen. And one of those rights that we find in the English Bill of Rights is the right, essentially the predecessor to our right to keep and bear arms, a reference to the traditional right of Englishmen to keep and bear arms. In the English Bill of Rights, however, it is a right that very clearly is referenced in connection with the right of Parliament to adopt and implement regulations, reasonable regulations of the possession of arms. So in the earliest context, it really was a concern that the king had exercised arbitrary power, but there was no objection. Indeed, there was specific endorsement of the right of the legislative body to adopt reasonable regulations of the possession of arms. Now, it's possible that when the framers drafted the Second Amendment, they were not aware of that history, they were not concerned with that history, were not replicating it in some way, but it's pretty clear that the experience of the English in 1689 had a very profound impact. That's why the Second Amendment really comes into our Constitution. So, what about a well-regulated militia? Well, was there a special concern at the time of the adoption of the Constitution with possible problems? Was it a concern with self-defense in the home, or was there another central core concern? And I think any responsible historian will say The central concern of the framers in drawing up the Bill of Rights was a concern that this new central government, with substantially expanded powers, might create something like a standing army, and the states themselves would be left defenseless if the central government were to use that standing army to, I think the concern was actually to invade and restrict the rights and prerogatives of the states. So the reference to a well-regulated militia was a reference to the state militias, and the basic concern was a concern that this new central government might act in a tyrannical way with regard to the states, in a way that was similar to the way that King James had done with respect to what King James had done, by the way, and I forgot to mention this, was he had actually disarmed the Protestants in England. That this new central government might somehow exercise tyrannical power with respect to the states and deprive the states of their ability to be free states in the meaningful sense of that word. Now we fast forward through time. All throughout the 19th and 20th century, the courts routinely, and I agree with Professor Lund, without very much examination, just assumed that that right was a right to be exercised in the context of a well-regulated militia. And the significance of the Heller case, as he has indicated, is for the first time the court rejects that view and says the right includes a right to keep and bear arms for purposes of self-defense. Now, I want to put a caveat on that because the Heller court did not say so broadly. What it ruled was that a D.C. ban on possession of handguns in the home was unconstitutional. And when the court speaks of the right to keep and bear arms, it very specifically says the right to keep and bear arms for purposes of self-defense in the home. And one of the questions that Professor Lund and I might want to discuss a little bit later on is, well, what are the implications of that, if any, for the right to carry concealed weapons or the right to carry weapons openly in public places? Heller says nothing about that. So, what's my view of Heller? My view is that it's a 5-4 decision. It's not irreversible. I think it's unfortunate that in that case, the majority cut the anchor to history and created this sort of free-floating right of individuals to bear arms, at least for purposes of self-defense in the home. That's my own view. I don't think it is historically sound, but 5 members of the court thought so we have to live with that case and follow it at least until it is overturned. Now, there are several parts of that opinion that Professor Lund referred to, and I will just say that it seems to me that they make eminently good sense, although they don't coherently follow from anything. One is that that doesn't mean you can't prohibit keeping and bearing concealed weapons in public places. Indeed, the court suggests that a ban on concealed weapons, which had long been the practice throughout the 19th and 20th century, might well be consistent with its ruling in the Heller case. Second of all, the court very specifically said that does not mean you cannot prohibit felons or the mentally ill from keeping and bearing arms. Third, the court said that doesn't mean that states and the federal government cannot prohibit individuals from carrying weapons in, quote, sensitive places. And they mentioned schools, maybe hospitals, things like that. But that's kind of an invitation to reasonable regulation, open to challenge. And finally, the court said that doesn't mean that the states and the federal government could not impose conditions on commercial sale. So all those kinds of regulations, the court seemed to say, would not be inconsistent with its decision in Heller. Now, I agree with Professor Lund that the court left many questions unanswered in that case, but at least it seemed to suggest that whatever the answer was, whatever the standard of review employed, it would not prohibit reasonable regulations of the sort that I have identified. Now, I want to jump to the question of whether the Second Amendment, which contains some pretty specific language, should be interpreted in the same libertarian way, subject to the same judicial scrutiny that, say, First Amendment freedoms, in particular freedom of speech, should be held to. I think that's a legitimate question. My own view is that we adopt a libertarian view of freedom of speech, not because of the text or a literal-minded reading of the text so requires, but because it makes good sense in a democratic society. Justice Brandeis, writing in dissent in writing in concurrence in the Whitney versus California case, said the reason why we protect speech, even dangerous speech, is because if we allow it to be suppressed, it will drive the poison underground. It's much better to allow that speech and subject to the ventilation of public scrutiny and allow for argument and counter-argument than to allow it to be banned and suppressed. In a famous passage, he said, "Fear breeds repression, repression breeds hatred." Now, when I'm looking at the Second Amendment, I don't see the same policy arguments underlying a literal-minded or a strict reading. I don't think the reasonable restriction of the use and possession of firearms is likely to lead to those adverse consequences. So I question whether that's a good analogy, and my answer would be it would depend on whether the underlying policies are so served. Having said all that, there's much about what Professor Lund said with which I agree, but I'm not sure if I agree that that should therefore authorize the courts to get in there and mess with thoughtful and responsible legislative judgment. One thing, when we have tragic events like that which occurred in Newtown, Connecticut, or at the naval base in the District of Columbia just last week, one of the gut reactions of the public is to call for measures of radical restriction of firearms. And I agree with Professor Lund that I don't know that there's any hard evidence that such restrictions are likely to significantly lead to diminution of such attacks. All the statistics show that about 50% of those mass killing attacks that have occurred over the last decade have been carried out by people with suicidal tendencies. And they're looking for the big way to go out. In most cases, I think the evidence will show, even if we banned all sorts of assault weapons and large capacity magazines, those that are intent about going out with a big bang are going to be able to get their hands on it. So I think at least raises the question politically whether such bans are likely to be effective. A second thing about political reality, and I think we all have to recognize it, and there's a divergence, it seems to me, between what the Constitution requires and the political realities involved, and it's a frustrating divergence, but it exists. The political reality is that it's very difficult to get even the simplest measures of gun control passed. Totally stymied in Congress, right? Okay. So you look to the states, and there have been a few states that have taken measures, but Colorado experience is sobering. They're two of the legislators who are responsible for, it seems to me, fairly modest and reasonable gun control measures voted out of office by the people just last week. If anything, if you look at the pattern, there's been much more legislation eliminating existing restrictions on gun ownership and possession than in the past several years than there has been vice versa. If anything, these efforts to adopt gun control legislation are likely to just lead to a spike in gun sales. So for me, without getting into too fine a point on what standard of review the court should use, I think the most one can hope for is that courts will allow sensible restrictions on gun ownership and possession. Ban on carrying concealed weapons. Perhaps restrictions on carrying weapons openly. I think total bans are likely to be in trouble, quite frankly, in the courts, but certainly that would not prohibit very responsible gun registration and licensing requirements. The gun lobby often talks about onerous or burdensome requirements, as if you have onerous or burdensome requirements, that's the end of the Second Amendment as we know it. And I suppose it depends on how you characterize these requirements. But I don't think you need to have a 30-30 and be able to carry it around in a shopping mall openly or as a concealed weapon for purposes of self-defense or anything else. So that to me would be a restricting, perhaps licensing the use of weapons, but restricting the places where they can be carried might be something that the states could try to do. Background check, that system can be improved by eliminating loopholes in the purchase and sale. I don't know if it would be effective, but I don't think that a ban on large capacity magazines or a ban on military style assault rifles would violate the Second Amendment. I just don't think politically those kinds of bans are going to have very much of a chance. I would like to think that the courts, at least, would not step in and interfere with responsible legislative judgment. I want to end by saying there are two things, it seems to me, at stake here. One is legislation that would lead to the end, how can we put it, would lead to a disarmed citizenry. Do you know what that means? Somehow it would disable the citizens of a state or of a political entity from collectively acting to resist some tyrannical exercise of power. I don't see anything in any of the proposed legislation that would lead to that result. I think if what you're concerned with is disarming Rambo, that macho guy who likes to carry, an AK-47 around, that's very different from a disarmed citizenry. And I think that's a distinction that should be kept in mind by the courts when they review legislation aimed at imposing some sensible restrictions on gun ownership and control. Thank you.
Of arms as provided in the Second Amendment. Is the regulation of ammunition more or less likely to be attained than the regulation of guns?
Ammunition is included within arms for purposes of the Second Amendment. There's no difference between the two, between guns and ammunition.
In today's world, what is the difference between a regulated militia and a terrorist group?
I guess that comes from the libertarians somewhere out there.
A well-regulated terrorist group?
Maybe they miswrote. They meant an unregulated militia and a terrorist group. Could that be what that?
Perhaps, yeah.
Let me say a word about the militia, because it's kind of an interesting history. And this is going to be very incomplete, but the militia at the time of the founding wasn't anything like our National Guard. There was a basic distinction between the militia, which means ordinary civilians who are compelled to engage in unpaid part-time military exercises and who are called upon to engage in military service during emergencies of one kind or another. They were often expected to provide their own arms, not government-issued weapons. And in the first Congress, they passed a Militia Act specifying exactly what kind of guns those who were eligible for militia service were required to get. Troops are carefully distinguished in the Constitution. Troops, our armies, are different from the militia. That's full-time paid professional soldiers. And one of the great debates at the Federal Convention, the Philadelphia Convention, was whether the new federal government, the new national government, was going to be allowed to raise armies without any restriction. There were a lot of people in America at that time who feared, because of English experiences in English history and also during colonial times, they feared standing armies, and they wanted the federal government to be reliant on militia, which is much less tractable form of military power. The debate at the convention was resolved in favor of giving the new federal government almost unlimited power to raise armies, including standing armies during peacetime. But the militia tradition continued in our law, although not in our practice. Today, the militia consists of all males between the ages of 17 and 45, with a few exceptions, and some females, primarily female officers in the National Guard. So the unorganized militia still exists today. A lot of you are members of the unorganized militia pursuant to a federal statute. Unfortunately, I've gotten too old to be subject to this form of taxation of being called up for militia duty. But the organized militia, which is the National Guard, is something different from what the founders thought of as the militia. And in fact, during the founding time, they were very afraid of organized militias like the National Guard. That had been tried in England by the Crown. And that was called the select militia. And that was very much frowned upon in public opinion. So the unorganized militia, which consists of a lot of you who may or may not be armed, here in Vermont, there are some states where you wouldn't be without being a criminal, but you are the unorganized militia, and that is not a terrorist organization in the view of the founders, and certainly not in my view.
I might just add that when the Second Amendment was initially being considered by Congress, and there was a second provision after the right to keep and bear arms shall not be infringed. It said, provided that those with religious scruples shall not be required to do military service. So you begin with the militia and you ended with the militia, and that last phrase was dropped. But that just indicated that the central preoccupation was with somehow the relationship of bearing arms to participation in a well-regulated militia.
Article 1, Section 8, Clause 16 of the Constitution grants Congress the power to provide for organizing and arming the militia. To what extent might this clause provide Congress with authority to regulate arms? Does the Second Amendment limit this clause?
Well, I'm very happy to hear that question, because it gives me an opportunity to answer the question that Justice Scalia decided not to even try to answer, which is, what does the prefatory language about the militia in the Second Amendment have to do with the operative clause, which is about the right of the people to keep and bear arms? As the questioner notes, Congress in Article 1 of the Constitution is given virtually unfettered authority to regulate the militia, as it has the power to regulate the armed forces. It's given virtually unfettered authority to regulate the militia. Now, that was something that people worried about at the time of the framing. A lot of people were very worried that Congress shouldn't have that power, because it would give a tool that could be used for oppressing the people and the people through their state governments. Well, how do you solve that problem? Can you write something in the Constitution that tells Congress, well, what kinds of militia are okay, what kinds of regulations of the militia are okay. It's probably not possible. And so one of the things that people don't recognize when they read the Second Amendment today is that the term well-regulated does not necessarily mean heavily regulated or more regulated than it is now. One way in which you can have something that's not well-regulated is if it's overly regulated or inappropriately regulated. And that's what the Second Amendment does. It tells Congress that under the color of your Article 1 authority, including your authority under the Necessary and Proper Clause, there may be all kinds of things that you can do to regulate the militia in ways that don't make sense, or that even lead to the non-existence of the militia, which is essentially what's happened in practice. You can basically destroy the militia through your regulations. But the one thing you cannot do, and the one thing the Second Amendment tells you cannot do, is invoke your Article 1 authority to disarm the citizens who make up the militia. There was no controversy about this, none at all at the time. No, some of the Federalists, Hamilton and originally also Madison, thought that this whole Bill of Rights was kind of silly, because the federal government wasn't given any authority to do things like regulate free speech, establish religion, infringe on the right to keep and bear arms. The Anti-Federalists and a lot of other Americans weren't so sure about that. And so the Bill of Rights was written in order to prevent Congress from exceeding its limited authority under the doctrine of enumerated powers.